I'm sure you know that more than 40% of first marriages end in divorce. But what you may not know is that if you don't take steps now, your child's future ex spouse could be entitled to a significant portion of the inheritance you leave behind. But you can prevent that with smart estate planning, and I'm going to show you how. And make sure you stick around because I'm also going to be telling you the biggest mistake that far too many people are making that is costing their children thousands. Here's how this usually plays out. A parent passes away, leaves their assets to their child. That child, let's say it's your son, deposits the money into a joint account with his spouse. They use it to buy a house, maybe make some investments together. Then the marriage ends. Because that inheritance was commingled with marital assets, it's now considered marital property. And guess what? The ex-daughter-in-law could walk away with half. You didn't work your whole life for that. So how do you protect your family from this scenario? Here are 3 proven strategies backed by real-life examples I've seen time and time again. Number 1, use a trust. Let's say you leave $250,000 to your daughter, Emily. If she receives that as a direct inheritance, it's up to her to keep it separate. And one slip, like moving it into a joint checking account, can turn it into marital property. But if that same $250,000 is placed into a trust, let's call it the Emily Family Trust. She can still benefit from the funds, but legally, she doesn't own them outright. That means if she divorces, the money in the trust is generally off limits to her ex. She can use the trust to pay for a down payment on a home, but it can be structured so that only the trust, not her, holds legal title to her portion of that house. That keeps it protected. Number 2, add a spendthrift provision. This is one of my favorite legal tools. It's like a shield around the trust. Here's what it does. It prevents creditors, lawsuits, or even a divorcing spouse from accessing the trust funds before they're distributed. So let's say your son Jake is going through a nasty divorce, and his soon-to-be ex's lawyer is trying to find every dollar they can. The assets inside Jake's trust? Off limits. Why? Because Jake doesn't legally own the trust assets. He only has the right to receive distributions, and those distributions are controlled by the trustee, according to your rules. Now here's where it gets important. Once the trustee does make a distribution to Jake, say $5,000 for living expenses, that money is now in Jake's hands. And at that point, it's fair game. A creditor or an ex-spouse can potentially access it because now it's Jake's property, not the trust's. That's why timing and discretion are so critical. You can give your trustee discretion to delay or limit distributions during risky times, like during a divorce, lawsuit, or financial trouble. It's like putting a pause button on the money until the danger passes. This approach helps ensure that your child still gets the benefit of the inheritance without it becoming a target during their most vulnerable moments. Think of it like giving your child a debit card with a strict spending limit rather than handing over your whole checkbook. You're still looking out for them even after you're gone. Number 3, avoid outright gifts. Sometimes families think, let's just give the kids the money now while we're alive. And I get it. It feels generous and loving. But let me share a quick story. I worked with a couple who gave their son a large financial gift to help him and his wife buy a house. They didn't document it properly. It wasn't structured as a loan or protected in any way. A few years later, the marriage ends and the wife walks away with half the home equity, including half of mom and dad's gift. But it didn't have to be that way. What they should have done is place the money into a trust, something like the Smith Family Trust, with clear instructions that it can be used only for their son's benefit. That way, the trust, not the son, would technically own the funds. The trustee could have paid the down payment directly or arranged it so the trust held a partial ownership interest in the house. Even better, they could have included a clause saying the funds could only be distributed if their son had a prenuptial agreement in place, or required the property be titled in the name of the trust. Same gift, same loving intention, but with smart legal planning that could have saved hundreds of thousands of dollars and a whole lot of heartache. The lesson: gifting can be great, but do it smartly and with legal guardrails in place. This isn't about distrusting your child. It's about protecting them from bad luck or bad decisions. Now let's think bigger. What if your goal isn't just to protect your kids, but your grandkids? A trust can be designed to span generations. You can decide how the money is used, who oversees it, and how long it lasts. This isn't just legal paperwork. It's how families build lasting financial legacies. Because the real goal isn't just avoiding divorce drama. It's making sure your life's work supports your family for decades to come. If you're feeling like this is complicated, you're right. It can be. But if you need help, we've got resources linked below, and you can book a free consultation with us anytime. All right, and here it is, the biggest mistake that far too many people are making: relying on verbal agreements or vague instructions, saying, "My daughter knows how to keep the inheritance separate," or she promised she'd use it wisely doesn't hold up in court. Intentions don't matter, legal structure does. And without it, your estate becomes a legal free-for-all. If you're serious about keeping your legacy in the right place, it's time to build a real plan, and big part of that can be a trust. If you're not sure what that is or how it works, check out this video here where I break it down for you in under 2 minutes. If you're finding this helpful, give this video a like and subscribe so you don't miss future tips on protecting your legacy. Thanks for watching, and more importantly, thanks for caring enough to plan ahead. Your family will thank you.